You brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. In the course of your lawsuit, you go on vacation, and now you want to post on social media, on Facebook, on Twitter, on LinkedIn, every place you've been to, and all the activities that you're participating in. You want to know why that's a really bad idea? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against your doctor claiming that number one, he was careless, number two, that his carelessness was a cause of your injury, and now that your injuries are significant or permanent. Now your case is going on for what seems like forever. Now you're already into the first full year from the time you started your lawsuit, and there's no end in sight for you. Although your lawyer did tell you this could take anywhere from 2 to 3 years in New York to get to trial. All right, so now during the course of that litigation, you and your family decide to go away on a much needed vacation. And while you are away, you are doing as many activities as you possibly can. You don't want to be stuck in the hotel room wondering, okay, what's my family doing? You want to participate with them. So what do? You actually go ahead and start participating. You try and walk with them. You try and go on different boating activities. You try and do whatever they are doing in order to be with them. Because that's the whole goal of being on vacation with your family, right? Your goal is to try and do everything possible. Now, your injuries certainly are limiting, and they don't allow you to do everything that you used to do. But in today's day and age, so many people say, you know what? I want to post to the entire world. I want my friends and followers on social media to actually see what I'm doing, to see what I'm trying to do. Well, I wanted to share something really important with you. If you happen to bring a lawsuit and now you claim that your injuries have disabled you and now have limited your activities, if you were to go ahead and post all of your photos, all of your videos about different activities that you are doing, guess what? During the course of your lawsuit, I guarantee you that the defense is going to find your social media information. They are going to capture that in a screen capture, and now they are going to use all of that information against you, because when you get up to testify at trial, they are going to use it to cross-examine you, to show to the jury that your injuries aren't that bad. Hey, if they're so bad, how did you wind up going on vacation to a foreign country? How did you wind up going on a boating trip with your family? How did you wind up going bicycling? How did you go mountain climbing? How did you go rock climbing? If all of your activities are that disabling and that significant that you are no longer able to participate in these activities or are limited from doing so, by posting those pictures, assuming, of course, that you're able to do these things, now you've set up a huge problem for yourself. Now you've got clear contradictions between what you testified you could not do or are limited from doing with what the defense has now caught you posting on social media, and now it's a clear conflict for you. And it's a problem for your credibility, because the jury is obviously going to look at this and say, I don't understand. You're claiming you can't do all these things, and yet here you are on social media, on Facebook, posting all these pictures on Instagram. What's the deal here? And if the jury determines that you are not credible, that you are not believable, guess what? There's a good likelihood they'll throw your case out and you'll get absolutely nothing. In addition, if the judge finds that this was intentional, guess what? Now what you've done is you've lied. And now there's the possibility and other repercussions that can occur that are significant. So the bottom line is, if you are bringing a lawsuit claiming that someone caused you harm and injury, and now those injuries are disabling, guess what? Do not post anything to social media. Do not post about your medical condition. Do not post about your activity level. Do not post about anything that could be used against you at the time of trial. Best thing to do? Stay off social media. Stay off Twitter and Facebook and LinkedIn and Instagram and Snapchat. Why? Because nothing you post on there is ever going to help you in your lawsuit. So why do I share this great information with you? I share it with you just to give you an inside look at what actually happens in these civil lawsuits involving accidents and medical malpractice matters here in New York. You and I do recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207. I'm Gerry Oginski. Have a wonderful day.